If you're facing a custody issue or just want to know your rights, you won't want to miss this one.
One parent just seems unable to care for the child. The courts will even consider alienation. Just the added knowledge that this is going to be available to the courts should you go back generally cuts down on a lot of the disrespect that might happen or name calling, things of that nature, and can create a much more peaceful co parenting relationship.
Welcome back to Law Unpacked. I'm attorney Sean, and today we're diving into a topic that impacts countless families: child custody in Florida. We're going to tackle the basics, from time-sharing arrangements to what happens if a parent wants to relocate out of state. But we're also covering how to put your best case forward and choose the right lawyer. Josh, I want to welcome you back, our in-house family law attorney here at the DeVries Law Firm. Welcome back.
Thanks, Sean. Always good to be here.
So tell me, what exactly is child custody and how does Florida define it?
So, Florida defines it as the legal rights and responsibilities that each parent is going to have going forward in the child's life. With that, you're looking at who's going to be having physical custody of the child, as in where the child's going to spend each day and night, and then decision making. That's going to be either shared responsibility or sole parental responsibility. Generally, it's shared. That's what the courts prefer. With that, each of you are going to need to confer when making decisions about the child's health, schooling, religion, things of that nature. As far as the physical custody, currently, Florida has a rebuttable presumption that 50-50 or equal time sharing is in the child's best interest.
Florida uses the term time sharing rather than custody. How does that shift affect how parents and courts approach these cases?
So it generally makes it a little easier since we've gotten rid of the majority custody term. Parents can be more willing to work together, knowing that neither of them is going to be the majority parent when it comes to time sharing. If one does have more time, we now refer to that as the custodial parent. It's just easier to work together without one party saying, well, I'm the majority parent, and therefore they think their opinion matters more when it comes to the decision making, which is simply not true.
When people talk about sole custody or joint custody, how do those ideas translate into Florida's time sharing model?
So Florida doesn't exactly have a sole custody. Even if one party is going to have a large portion of the time, the other parent is referred to as the non custodial parent and will still have some sort of time sharing. Even in extreme cases where there's been abuse or neglect, that parent is likely going to have time, even if that's only supervised time. If it's sole custody by one party, the courts are likely going to be looking to terminate the parental rights of the other parent, and that is only in extreme cases.
So, if two parents can't agree on time sharing, what factors does a Florida judge consider?
Currently, we're under a rebuttable presumption of 50-50. So unless factors greatly weigh one side or the other, equal time sharing is going to be what's put in place. The factors the courts are going to be looking at are whether or not there's been domestic violence. They're going to look at geographic viability, which is where the parents live and could they effectuate that 50-50, and if not, what kind of time sharing would be appropriate, given that the child is going to need to go to school, have doctor's appointments, things of that nature. Courts are also going to look at the physical and moral fitness of each parent. If the child has special needs, if the parent, you know, can't physically, for whatever reason, take care of the child, that's going to be something that's considered. The child's routine and stability. If you were previously living together, now you're living apart. We want to keep that stability in place. So if we're going to designate one parent to have a larger portion of time, we'll likely want it to be that parent that's staying in the home where the child's used to, where the child's zoned for school. The courts are also going to want to look at designation of third parties if you're going, such as if you're going to need daycare for the child during the day or in the evenings, and the other parent wouldn't need that. The courts would rather the child be with that parent as opposed to the third party. And another thing the courts are going to look at is your willingness to foster a relationship between the child and the other parent. So if you are trying to alienate the child from the other parent, the courts are certainly going to take that into consideration when determining what is in the child's best interest.
So, is it still true that mothers have an advantage in court, or is that just a myth?
That is a myth. In 2023, Florida enacted a rebuttal presumption of 50-50, meaning there is no gender bias towards either party. Um, Previously, there may have been a slight favoritism towards the mother, especially when it comes to younger children who may have been breastfeeding or other things of that nature for very young children. But those are all gone at this time.
What role, you mentioned the best interest of the child earlier. What role does a child's preference play, and at what age is their opinion taken into account?
So the child's preference is listed in the best interests of the child factors. However, very rare that we get into that in cases, which I know sounds counterintuitive, but the child's statement to either of the parents would be considered hearsay, which is not allowed under the evidentiary rules in Florida. And if you want the child to actually testify, you would need to get special permission from the court. We would do a motion for child testimony. At that time, the court would consider whether that would be appropriate or relevant. Um, there is no hard set age at which the court does that. They base that on the maturity level of the child. Now, generally, around age 15 to 16, the courts will allow that. I've seen it as low as to age 12. Anyone younger than that, the courts are likely going to ask for a third party to interview the child and make a report on their behalf. Generally, in these cases, you'd be looking at a social investigator, and with that, a great deal of added cost to you. Um, the social investigator would make a report based on all of the factors and what they consider to be in the child's best interest.
So, how does a parent's work schedule or lifestyle factor into the court's decision?
The work schedule can certainly factor in. Again, as we discussed in the best interest factors we just talked about, the ability to not use third parties is something the courts are going to look at. So, if your work schedule, you work overnight, you would need the child to stay with a third party overnight. The courts are going to tell you, well, they should just stay with the other parent instead. As far as your lifestyle, again, if you're out all hours of the night, the courts might prefer that the child stay with the other parent as opposed to being with a third party or being at home alone. Or if you are consistently out at bars drinking, the courts may look at your finances and want to question you about that and have their concerns addressed.
Well, what if one parent has legal issues? Could that automatically impact their time sharing?
It could, it wouldn't automatically. We've had cases where there's been domestic violence or where there's been child abuse in the past. It's not an automatic bar or even that you wouldn't receive 50-50. We've had one recently where there was child abuse in a case, and that party was still granted 50-50. The court determined that they had gone through all the rehabilitative steps that they needed to and were not a threat to the child at this time.
Does paying child support give a parent automatic visitation or time sharing rights?
It doesn't. In fact, cases usually start just the opposite. if a parent files for state benefits, before they can receive those benefits, the Department of Revenue is going to put the non custodial parent on child support with absolutely zero time sharing in place. It's not addressed in those cases. So generally, you're put on child support and then need to file for custody. And your child support will not change until the custody determination is made.
Let's reverse the question. If someone refuses to pay child support or is behind in child support, does that stop them from getting custody?
No, those two don't work together in that way. If someone's not paying child support, you would need to file a contempt with the court. If you withhold the child, then you would also be in contempt. And the courts are more concerned with each parent seeing the child than with the payments. So just because someone's not paying their child support is no reason to withhold their time sharing.
If a parent loses a job, what steps must they take to modify child support?
If you lose your job, you'll want to file immediately with the courts to modify your child support. Um, the court can put that in place retroactively, but only to the date of filing for the modification. And they do that for ease, that they don't have to go back and determine your exact date. They just use that date that you filed. So until you do, you're going to be on the hook for that higher child support amount. And those arrears don't go away. Even after the child's 18, if you didn't pay them because you weren't making the same amount of money, you'll still owe them, and the courts will just extend your payments out. We've seen people paying child support into the 40s of the child because they never filed to modify their support when taking a lower paying job.
In Florida, what's the difference between child support enforcement and child custody enforcement?
So, child custody enforcement is going to be done by the courts. They're just going to tell you that you have to let the other parent see the child. If you don't, it can affect the amount of time you have with the child, and they may change the time sharing based on your unwillingness to abide by the court's child support order. Child support enforcement is a much different thing. If you're working a regular 9 to 5 job, the court can just put in place what's called an income withholding order, and they'll pull the child support directly from your income. Now, if your employer fails to do so, then the employer would become responsible for the child support. So I have never seen an employer not pull your child support once they're ordered to do so by a court. People who are paid under the table, if you're not paying, you'll generally be looking at a uh, slight sanction from the court, likely a reprimand. After that, you can be looking at your license suspended, all the way up to having to go before the court for a purge hearing, which is where the court is going to tell you you owe a specific amount of money towards your back child support, and it's to be paid within a set amount of time. And if you don't make that payment, then you will be incarcerated.
Wow, so you're telling me you can essentially go to jail if you don't pay your child support.
That's correct. Now, that is mostly in extreme cases. The ones where I've seen it occur, the person is generally over $100,000 in child support arrears.
How do courts handle a parent who can't afford child support but still wants involvement in the child's life?
They will give you the time outside. Again, it's, support is unconnected to the custody. Not being able to pay child support is not something the courts consider. Again, they have a formula for what you should be able to afford. And so if you can't afford that, the court's going to tell you you need to adjust your lifestyle because the child being taken care of should be priority one.
Custody battles can be stressful, so what are some common reasons a parent might lose time sharing?
The main ones that we see since the courts changed to the rebuttable presumption of 50-50 are domestic violence against either the other parent or the child, or geographic viability, where one parent would move to a location where they can't get the child to school and things of that nature during the school year. But those have been the two big ones since we've made that change in the state of Florida.
Now, that change happened in 2023. Is there a way to modify your agreement if it was uh, enacted prior to 2023?
Unfortunately, no, it's not retroactive. If you want to modify, standard modification would apply. You'll need a substantial change in circumstances.
And what are those typically substantial change in circumstances? What has the court decided as what were valid substantial changes in circumstances?
So that would generally be, again, if there's been domestic violence, if there's been a move by one parent to where working out the time sharing would no longer be effective. If your schedule changes and you can't keep the child and you're now going to need a third party to assist, um, if there's a drastic change in lifestyle to where one parent just seems unable to care for the child, the courts will even consider alienation if one parent is attempting to disrupt the relationship between the child and the other parent.
So just to confirm, or just to confirm what we're discussing here, if so the 2023 50-50 rebuttable presumption law that came into effect in 2023, you can't go back and modify that 50-50 now because there's no retroactive. However, if there's a substantial change in circumstance, then you could modify it and apply the new law.
You can the new law would apply, and it would be 50-50 if that's what the courts decided was in the child's best interest, or if the change in circumstances would necessitate you being now the majority custody parent or the custodial parent. The courts would put that in place just as they would have before.
So, which brings me to my next question. Let's say a parent wants to move out of state or even out of the country. What legal steps are required?
So you're going to need to file with the court. With that, you're going to need either the permission of the other parent or the permission of the court. If you don't have the permission of the other parent and you're looking to move out of state, or especially if you're looking to move out of the country, the courts, most of our local judges, will have a social investigation done to see if the relocation is in the best interest of the child.
Is there a difference between relocating within Florida and out of state?
No, what we have for our relocation statute is a move of 50 miles as the crow flies. That doesn't matter if you're moving from Duval County to Miami or from Duval County to right across the border in Georgia. Uh, the courts are going to consider those the same.
So, if the relocating parent has a compelling job offer, does that help their case?
It absolutely does. In fact, in the Florida statutes, if you are moving for job purposes, the courts ask that you attach a copy of your offer letter to your petition to relocate. So it's definitely a compelling reason, and one of the main ones that we see for parents wanting to relocate.
So, taking that down just a little bit, not all custody cases are high conflict. What tips do you have for parents aiming to co parent effectively?
Put the child first is always the best advice. You don't want the child going into special times in their lives, graduations, award ceremonies, things like that, with the tension of what's going to happen when mom and dad see each other at this event. If you can put on a united front in front of the child, that's going to be the best for everyone. The two of you getting along is going to make your lives so much easier. You're going to have at least 18 years to deal with each other. All you parents know, it's going to be longer than that. Getting along is going to be the best thing for everyone.
So, our viewers are probably watching this on some form of social media. Tell us, how does social media activity impact a custody case?
Far less since went to the rebuttable presumption of 50-50. Beforehand, it could, a negative post about the other parent and still can be used to show that they have an unwillingness to foster a relationship between the other parent and the child. Where this particularly comes into play is if, say, you're posting on a social media platform that your child follows you on or is friends with you on, and will see these negative comments about the other parent. Part of the mandatory provisions in all of our Florida custody cases are that you will not make disparaging comments about the other parent to the child. Those social media posts can affect that and even have you be in contempt if there's already a custody plan in place.
Moving from social media to apps, right? We have there's lots of co-parenting apps out there. How do they help reduce misunderstandings, and do you recommend them?
We do recommend them when there are any types of issues with communication with the parents. Um, the two we mainly use are Talking Parents and Our Family Wizard. They create a log that cannot be modified. You'll know when the parent saw the message you sent. You'll know if they've responded. The courts will be able to see that. And each parent knowing that the courts will be able to access these documents, even though the courts can always be provided with text messages, just the added knowledge that this is going to be available to the courts should you go back generally cuts down on a lot of the disrespect that might happen or name calling, things of that nature, and can create a much more peaceful co parenting relationship.
For parents that are worried about losing custody, and I know this is a, we've changed the law here in Florida, so it's now that 50-50 with a rebuttable presumption. What proactive steps can they take to strengthen their case?
When you are talking with the other parent, be cordial. Um, if you two don't have a current time sharing plan in place, try to keep it consistent even before going to court. Always put things in writing. Generally, a text message is fine. If you're requesting time, if you are letting them know that the child has a doctor's appointment, keeping the other side informed, doing so is going to greatly help your case. Just showing the courts that you're making an effort to co parent will go a long way for you.
How important is keeping detailed records like communication logs and or a visitation journal? And do you suggest organizing them? Or how do you suggest organizing them?
We do suggest them. What I generally recommend is a calendar with a color coordination of however you would like, of some type of requested time with the child. One color for if you got it, another for if the other parent denied. Also, call log. You can keep it on that same calendar. That's recommended. That way, you're only tracking one document. One color for if the parent took your call, another color for if the other parent didn't take your call while you were trying to call and speak with the child.
Based on what I've heard today, I'm not sure if this really applies anymore, but I feel like there are some cases that it does. What role would character evidence, like positive references from family or teachers, play in Florida custody cases?
Correct. Far less relevant now since the law changed, but going to be very helpful for cases where the other party is trying to defame your character and put you in a state where they're requesting majority time because of your moral fitness, which, as I believe I stated to one of your previous questions today, is one of the best interests of the child factors. And so, in those cases, character evidence will be greatly beneficial. Please keep in mind, statements from those people will not suffice. Those are considered hearsay. You will need them to appear in court to testify on your behalf. But generally, we save those for specific allegations of misconduct as opposed to overall character evidence.
So let's say parents aren't getting along. Should parents consider mediation or counseling to resolve disputes before involving the courts?
Counseling, if you need it as parents, never a bad idea. As far as mediation, Before you get to a trial, the court will order you to mediation. Um, so, always advisable if you would like to do it before getting started to do so. Just know that if you don't, it will be ordered at some point if the two of you can't come to an agreement on custody before a judge will hear your case.
Josh, for our listeners out there that could be or are getting ready to go through a family law issue, what qualities should someone look for in a family law attorney?
You're going to want someone that understands your case. Every attorney is different. Some are more aggressive, some are more strategic and cooperative. We even have a type of law called collaborative law for family law. So you're going to want to go in knowing which way that attorney would go and how you think your case will go, and try to find one in coordination with how you think your case is going to go.
Well, should a person ever consider switching lawyers mid case? And if so, under what circumstances?
Yes, there are times where it is beneficial to switch attorneys mid case. Sometimes you don't feel your attorney is doing the job that you think they should be, um, which may or may not be true, but that peace of mind for yourself is very comforting. Or there are times where you don't trust your attorney to the point that you are tuning them out. And at that point, it would be recommended to find new counsel. That way, you are really listening and trusting the information that you're getting.
How do you balance cost and quality when choosing legal representation?
It's a big concern. Attorney prices vary greatly, and your budget may vary with it. If you hire, the most expensive attorney out there, and your budget can't support that, you're going to quickly find yourself with that attorney withdrawing as your retainer has been exhausted, and now you're without counsel. Whereas, had you found an attorney more in your budget range, they could cover the case perhaps throughout on the same type of budget that you expended on the more expensive attorney.
Does having an attorney with specific experience in Florida custody law make a big difference?
Absolutely. If someone doesn't have that experience, they may not know all of your rights to advise you on. They may not know all of the responsibilities that are required of you. They may not know that you need to be informed that you can't leave the state and relocate without the permission of the court or the other parent. And it's easy to find out if they do or not. You can always go on the Florida Bar website, pull up an attorney, see their history, what type of law they practice. Many family law attorneys, that will be the top thing listed for them. Such as if you go to my page, family law is the only thing that's listed. That is my main area of focus. Anything else I do outside of that is going to be secondary.
And what are the pros and cons of hiring a big firm versus a smaller, more focused practice like ours?
So, when you hire a big firm, you're likely going to have an attorney that you don't speak to, rarely, if ever. With that, they're likely going to have multiple paralegals that you'll speak to. They'll usually have one for their discovery, one for their drafting, and one for miscellaneous communications with you. Whereas if you hire a smaller firm, you're likely going to be dealing with one attorney and one paralegal. So when you call looking for an answer to a question, the person that you're speaking to is going to be the one who knows it. They won't need to transfer you, or you have to have a callback from another department to get the information that you're looking for.
Well, Josh, thank you for your time again. From understanding time sharing to choosing the right lawyer, if you're going through a custody situation, remember that knowledge is power. Doing your research, keeping records, and seeking out the right representation can make all the difference. If you found this episode helpful, please like, subscribe, and share it with anyone who might need it. If you have any questions, Drop them in the comments or send us a message. Your question might just help someone else too. Thank you for tuning in to Law Unpacked. I'm Attorney Sean. Until next time, stay informed and take care.